Good morning to all of you. Welcome to Jurisprudence class. So friends, today we are going to discuss the question on the sexual harassment of women at workplaces. The question number 17 of question paper 2018. The brief facts of the case are: government wanted socio-economic beneficial laws. Very good. So particularly regarding the women's rights at the workplace, and some people say that it is against to the principle of equality. Right now, since we are doing the jurisprudence class, it is a sociological concept plus economic. While going to the sociological school, American realistic school, definitely you will be understanding this problem. Yes, the women should be treated equally. Their dignity should be respected. So now the issue is whether government can make laws on socio-economic beneficial purpose. If so, can they spoil the privacy, or can they spoil the privacy of economic development or develop? So can they violate the principle? You can say principle of equality. Certainly no. Everybody is, Article 14 says everybody is equal in the eye of law, but Article 15 says no discrimination. Article 16 says so the people who are in the lower level, they should be uplifted. This is what is called protective discrimination. The women should not be discriminated, but they should be given the so-called protective discrimination. So simply to say, this is a case, this is an instance where we have to discuss the act. So harassment of women at Sexual Harassment of Women at Workplaces Act. If you mention this, this will be sufficient. Right. Now coming to the case. Act. Sexual Harassment of Women at Workplaces, within brackets, Prevention, Prohibition and Redressal Act 2013. So you all know that this act came as a recommendation of the so-called Vishaka guidelines or Justice J.S. Verma guidelines. Vishaka versus State of Rajasthan. Right. So before that, as already mentioned by me, Article 14. Equality before law and equal protection of all laws. Even in the preamble of the Constitution of India, it is said, equality of status and opportunity must be granted to all the citizens. Even in the SEDA, you all know, Convention on the Elimination of Discrimination Against Women, 1979, it is called as International Bill of Rights for Women. Equality of women in political, economic, social and cultural spheres. So they have to be given rights, economic rights, social rights, cultural rights, etc. Right? But in spite of telling all these things, the sexual harassment of women at workplaces is continuing in almost all the part of the globe. Across the globe today, sexual harassment of a woman, no doubt, they made it a violation of the woman's rights. So, when we are discussing the Vishaka case, Vishaka versus State of Rajasthan, 1997, there Banwari Devi, actually, who was right from her childhood, she was fighting against the so-called child marriage. When she went to that particular place to prevent the child marriage, and she was successful literally, but she was subjected to gang rape and the case could not stand in the court of law. Very pathetic case. Of course, if you read the case, you will be knowing the same. So definitely the socio-economic laws should be made to protect the woman, and as advocates we have to support the same. Is it not? Yeah. So let us discuss, let me give a couple of examples, case laws. So this is regarding sexual harassment of women at workplaces. KP Anil Rajgopal versus State of Kerala, 2015. KP Anil Rajgopal versus State of Kerala. Right. So here, actually this happened in Talaseri of Kerala state. So the woman, she is the complainant. Of course, her name should not be disclosed. She made allegations against the finance director that since she did not oblige his so-called sexual advances, sexual overtones. So normally people, I will tell that sexual overtones, since she did not agree for his sexual overtones, then she was subjected to harassment. The finance director started harassing her and he made false allegations. Now, what are sexual overtones? Means suppose people like me, I have become old, I cannot indulge in the so-called contact with a woman. So, I will be deriving satisfaction by speaking something. తెలుగులో సెక్షువల్ మాట్లాడుతూ ఉంటాం కదా, ఇలాంటి మాటలు మాట్లాడుతుంటే, ఎందుకంటే మనం చేయలేం కాబట్టి మాట్లాడి కొంతమంది అలాగే ఆడపిల్లల్ని సెక్షువల్ ఓవర్టోన్స్, నువ్వు చీర కట్టావే, చీర బొడ్డు కింద కడితే నీ బొడ్డు చాలా బాగుండే, చాలా అందంగా ఉండేవాళ్ళు, నీ బ్రెస్ట్ పోర్షన్ ఇలా ఉంది, ఇవన్నీ ఏదో మాట మాట్లాడుతుంటారు. దిస్ ఈజ్ యాక్చువల్ ఇట్ హ్యాపెన్స్. జరగదని మనం అనలేం, ఇట్ హ్యాపెన్స్. సేమ్ థింగ్ బట్ ఐ డోంట్ నో వెదర్ ఇట్ ఈస్ ఫ్యాక్ట్ ఆర్ నాట్. బట్ బికాస్ షీ డిడ్ నాట్, అంటే రేపొద్దున్న మంచి కట్టుకురా లేదా బొడ్డు కింద పెట్టి ఇట్లాంటి మాటలు చెప్పినప్పుడు వెన్ షీ డిడ్ నాట్ అబ్లైజ్, ఈ might have started the false allegations. Right. Ultimately, దీని మీద she has given a complaint to the internal complaints committee, and he said, no, she is ఆవిడ ఏంటంటే she was already abducted by somebody అని చెప్పి ఏదో వాగాడు. అంటే ఆల్రెడీ చిన్నప్పుడే లేచిపోయి ఎందుకు అన్నమాట అని అన్నాడు. అనేటప్పటికీ దట్ వాజ్ టేకెన్ టు వెరీ సీరియస్లీ, అండ్ యూ షుడ్ నాట్ కాల్ ద ఉమెన్ యాజ్ kidnapped or abducted. It is against to the so-called section 3 of sexual harassment of workplaces. So ultimately, the person, finance director, was taken to task. So that is protection of the right of woman, particularly in the economic wing. Second case, Gaurav Jain. In this case, Gaurav Jain versus Hindustan Latex Family Planning Promotion Trust. Hindustan Latex, there's a company, it's Family Planning Trust, and others 2015. Right. Here, Mr. Gaurav is saying, the services of the petitioner, they have been terminated because he harassed a lady employee. So her name is, should not discuss, lady employee. His conduct towards the female colleague during outstation, just like our Tarun Tejpal case. Tarun Tejpal, so while he was conducting an annual meet in that Goa, he has molested a young girl. She has reported the complaint. Ultimately, Bombay High Court recently acquitted, but the Honorable Supreme Court convicted him. So anyway, whatever it is, so likewise, his conduct toward the woman colleague during the outstation travel by intimidating her to hotel room or inviting her to the hotel room. ICC, definitely it is inviting to hotel room at midnight and take drinks and smoking, all these things. Definitely they are nothing but exploitation of woman, sexual harassment of woman. So definitely she has reported the matter. The ICC, Internal Complaints Committee, they have given a clear report, lucid report. Therefore, since he has misbehaved the woman, he was terminated from service. So therefore, at that time, Supreme Court of India also stated that counseling should be given to the male employees, particularly on gender sensitivity. The allegations are approved and he was terminated. So likewise, to conclude, you have to write that in view of the above discussions, it can be concluded that Sexual Harassment Act for the employees 2013 can be invoked if the necessity, basing on the necessity and basing on the recommendations of J.S. Verma, or basing on the so-called Vishakha versus State of Rajasthan, to give the protective discrimination for the woman. Definitely they can make the laws. They are not disturbing any principles of equality. No doubt, by gender, by the God created man and woman, no doubt rights are equal, but they are separate. Their sensitivity is separate. Everything is separate. So if you write this much, it is sufficient. Already 9 minutes over. So I think you get bored. Thank you very much.